Well, welcome everyone. Thanks so much for joining us this afternoon. Again, my name is Megan Anderson. I'm a partner at Lathrop GPM in our employment and labor law group. And I am joined today by two of my fellow employment law partners, Mark Matheson and Jill Waldman. And we also have with us today Julia Ryland, who is a partner in our health law group. And as advertised, we're going to be talking with you today about a number of issues that employers are facing as we are seeing, obviously not the end of the pandemic, but some easing of the pandemic and some easing and lifting of some of the restrictions we've all been living with for the last year plus. And as many of you employers out there are starting to think more about when you might return more of your employees to the workplace. The agenda that we're going to cover today is we're going to talk a little bit about what employers are thinking about and having to make decisions about in terms of their return to work approach. There are some safety obligations, as you probably know, that you have as employers around providing a safe workplace. So we're going to be talking a bit about those safety considerations, more broadly, and then in particular in connection with the different approaches that are available in connection with the COVID vaccine. Julia is here to tell you about some health law compliance obligations that may not be on your radar screen in connection with some of the approaches you might be taking around vaccine issues. And then we'll end with talking a bit around employee reactions to your potential return to work strategies, some of the practical challenges that you may face, and some of the protections that employees may have around return to work issues. So before we launch in, what I'm going to do is just cover a couple of quick housekeeping matters, and then we will get going. I want to welcome you all to submit questions throughout the presentation using the chat feature that's at the bottom of your screen. If you just click on that, as I'm sure you're used to with Zoom, you can send us your questions. We will be trying to answer those as we can throughout the presentation. And hopefully we will have some time at the end for some Q&A as well. If for some reason we do not get to your question, we are going to save those questions and we'll make sure that we individually reach out to you to follow up. The webinar is being recorded and we're going to make it available on our website along with the slides. Our schedule right now is to have that up on Monday. And so you'll all receive a follow-up email when that happens, directing you to how you can access the materials on our website. And you're certainly welcome to share the content with others in your organization. And the last housekeeping matter I want to mention is that we have sought continuing legal education credit for this webinar today in Missouri and Minnesota. And as soon as we hear back and hopefully get the approval we're seeking on that, that information will also be circulated to attendees. So with that, I am actually going to kick us off with talking about the decision that I know many employers are facing around return to the work site. So if we can go to the next slide. So obviously we have some employers, who had essential workers, or maybe due to the nature of their operations, they either never went remote at all, or only part of their workforce went remote. We have other employers where their workforce largely went remote during COVID. And so we're at a point with some easing of the pandemic and the lifting of some restrictions and the availability of the vaccine that a lot of employers are starting to think about what they are going to do with their remote workforce and whether and when they might bring people back. If we can go to the next slide, there's essentially, three options that I am hearing most employers talk about that. And I think the question is, are you going to go back to exactly the way that things were before COVID, right? Where for most employers, most employees were on site every day on a regular basis, or with this forced experiment that we had of going largely remote for many organizations, are your workplaces really forever changed? Are you going to be looking at some different sort of model in the short term, in the long term, or both? So, lots of employers are out there thinking about, are we going to bring everybody back? Is that the right thing to do? Are we going to keep everybody home? Maybe we liked telecommuting and remote work so much that that's the future of our organization. Or are we going to adopt some sort of hybrid approach? We're going to throw up a poll question to ask what those of you who are with us today, currently, to the extent that your organization is thinking through these options, what are your plans between these three choices? So we'll just wait a minute as folks can submit their answers here. And then we'll be able to see what you all are saying. So the majority of folks are saying that they're looking at some sort of hybrid. Very, very few are going to be all remote. And about a third are going to have everybody return. So that's just an interesting snapshot, at least of those we have with us today. If we can move to the next slide, I thought I would just touch on what I am hearing as sort of the primary factors that employers are thinking about as they're making those decisions around what the future of their workplace looks like. Obviously, every organization is unique. And so there may be some considerations you are thinking about that I'm not hitting on today. But the things that largely we are hearing about are, thinking about the nature of your industry and your operations. There are obviously, some types of organizations or particular types of positions, where as a practical matter, the work just cannot be done remotely. Think about manufacturing, for example, as a key example of work that often has to be done on site and in person. Your customer and client needs and their expectations are going to be important. Your ability to be able to provide a safe workplace, because as Jill's going to drill down on in a few minutes, you do have safety obligations under the law. The nature of a particular position's duties is going to matter in terms of whether that position in particular can be done remotely. Employee preferences may be part of your decision. Financial considerations may be part of your decision. I've certainly heard lots and lots of employers talking about how they were quite surprised at how effective it's been to be remote. And there may be some significant cost savings if they can shrink their real estate footprint. So that may be something you're thinking about. Obviously, you've got to think about whether you have the resources from a technology standpoint and from other vantage points to be able to support, to effectively support remote work. So those are some of the things that we are talking about. I want to drill down just a little bit on that employee preference issue. So if we can move to the next slide. I did a little bit of, checking around in preparing for today around what we were hearing about employee preferences. And I found an interesting survey that Prudential had done called the Pulse of American Workers Survey. They've done a series of these, and they're conducting a survey nationally among full-time workers age 18 or over, and trying to get feedback from workers around the country on their perceptions around various workplace policies and trends. And they did a survey in March around this particular return to work issue and what employees are wanting employers to do. And interestingly, some of this matches up with the poll we just did of those of you who are with us today. Almost 70% of the workers who responded to this survey said that they preferred a hybrid approach. And that's because 2 out of 3 of those responding said they recognized that there really was true value and benefit in some of the in-person interactions that we can only get through being back on the work site, in terms of collaboration, company culture, mentoring, career opportunities that are really hard to duplicate or replicate if you're not having those in-person interactions. But we also saw that almost 90% of the people who have been remote, at least to some degree during COVID, want to continue working remotely at least 1 day a week, if not more. And in fact, 42% said that if their employer did not offer long-term remote work options, they would be looking for another job. And so I find that in particular a really interesting statistic. Mark's going to talk towards the end of the presentation around a number of issues around employee reactions to return to work. But interestingly, the survey indicated that over 40% of workers have safety concerns about returning to the workplace. We obviously are not done with COVID. And that may indicate that you'll have some employee resistance or some employee morale concerns that you're having to sort through in connection with return to work on site. If we can go to the next slide, the survey also had some interesting information that I think gave some insights into why we're seeing such a significant number of workers saying that they want to continue being remote, at least part-time, and why we're hearing that that's significant enough to them that over a third of them would consider changing jobs if that's not an option for them. There were lots of reported benefits of remote work. They're all things I think that many of us who are working remotely and are here today probably have experienced ourselves. People are saving money. They're not having to pay for parking. They're not having to pay for gas. They're not having to pay for lunchtime meals. They are saving time, maybe not altogether, because we're also seeing on the flip side around downsides of remote work that there's, the boundaries right between home life and work are blurred when your desk and your computer are sitting there facing you all of the time. But because employees are saving that commuting time, we're seeing people report some real benefits, that they have more flexibility about setting their schedule, that they can spend more time with family and pets, that they're seeing some health improvements because they're using that commute time differently to get more sleep or to exercise, and that there's sort of a kind of a general reduction in stress, not sort of having the busyness that comes with commuting every day. The reported downsides, I think, tie back to that survey result where 2 to 3 people did say they recognize value of in-person interactions. There are certainly downsides in terms of more isolation, less ability to connect face-to-face with our colleagues. That has an impact on culture and connection. It has an impact on career development in terms of mentoring and the like. So interesting things to be thinking about as you all are deciding on what that return to work approach is going to be. I certainly am hearing on the employee preference front that a lot of employers are, if they are in a position to consider keeping some people remote because of the nature of their operations, a lot of employers are doing employee surveys. In fact, our firm has done that to kind of take the pulse of their own workforce and what their own employee preferences are as they're making these decisions. So if that's not something you've done, it's something you might give some thought to. So with that sort of introduction to the return to work topic, I am going to turn it over to Jill, who's going to spend some time talking with us about the safety aspects of returning to the office.
Thanks, Megan. I'm going to spend some time today talking about employer considerations as they relate to safety, specifically the new CDC mask guidance that was issued last Thursday, as well as the current status of temperature checks and other health screenings. As we all know, COVID is evolving, and state, federal laws, regulations, orders are all changing, and employers are simply left guessing how to navigate their workplace. While there remain a lot of unknowns and questions, it's important for employers to recognize that they still have legal obligations to their employees, customers, vendors, and visitors, and that these employers must give consideration as to how to navigate these legal obligations. Let's go to the next slide. So specifically, for instance, OSHA. Employers are under OSHA's general duty clause, all employers must provide a work environment free from recognized hazards that are causing or are likely to cause death or serious physical harm. So we as employers have an obligation to satisfy or to at least meet that OSHA general duty obligation. Pre-COVID, employers' safety obligations pertained or centered around evacuations, safety, fire safety, personal protective equipment, accident reporting, training, infections, and disease policies. And then with COVID in January of this year, OSHA came out with some guidance called Protecting Workers, Guidance of Mitigating and Preventing the Spread of COVID-19 in the Workplace. And that guidance is specific and it's fairly lengthy, But a key takeaway from that guidance was that employers have an obligation to implement COVID prevention program. Many states, and there are many local orders that require employers to have these safety or preparedness plans. But in any event, this is what we're seeing. And with respect to these COVID prevention programs or plans, we're seeing that employers are, they should conduct hazard assessments, identify control measures to limit the spread of COVID. Employers should adopt policies that don't punish workers. They should also protect against retaliation, and we'll talk about that in a little bit as well. And they should also communicate policies and procedures regarding the, in all applicable languages, not just your English speaking employees. Apart from OSHA, there's workers' compensation considerations that employers must consider. What we're seeing with respect to workers' comp, several states have taken action to extend workers' compensation coverages to include COVID-19 as a work-related illness. Several states have also enacted legislation creating a presumption of coverage for various types of workers. So you'll need to check with whatever state you're in to determine or see what or how your states are handling those workers' comp protections. I can tell you that in Kansas right now, there's no laws or any legislation. There was some legislation that was posed in June of this year, or June last summer. And there were two bills that were presented, and both of those bills died in committee. In Minnesota, in April of 2020, Minnesota passed a new law stating that certain employees who contract COVID-19 are presumed to have an occupational illness or disease. And with respect to that body of law, with respect to those certain employees were deemed to be like a firefighter, emergency technicians, licensed peace officers, healthcare providers, etc. There's also legislation pending in Minnesota that there's a new law that would expand the law to implement presumptive coverage for a COVID-19 contraction to employees of a public school district. There's also other legislation pending that would create a rebuttable presumption of occupational disease for certain school employees. So again, I think it's important that, that we need to see how our states are handling work comp laws. Negligence, I think that's important. I think we all understand what negligence is. We've all been tasked, or we've seen those types of issues arise where employers have an obligation to protect their employees, and to the extent they don't, there's anticipated litigation that we anticipate with respect to negligence claims. This is new. We don't really know what the courts or how the courts are going to handle these claims. But what we do know is that under negligence law, there's two factors that are of critical importance. One, you have to look at the behavior of the employer, and two is the question of causation. And so we believe that if employers are implementing guidance or following guidance and implementing plans and safety plans and whatnot, that we believe that that will at least give them a defense, that they took, that their behavior, was not negligent. Courts also will look to guidance on the standard of care, and they too will look at how agencies and whatnot are handling these types of issues. So it's important that employers at least attempt, to create or have a safe working environment. Waivers. I've been asked, and I'm sure Mark and I'm sure Megan have been asked about waivers and whether or not waivers can be used with respect to their premises, specifically as it relates to vendors or customers, visitors, or with respect to certain activities. These waivers can be effective, but I think most importantly is that state law will determine whether or not any liability waivers will be can be used. With respect to waivers, also certain conduct can't be waived under the law, and that would be like gross negligence, gross negligence. Also, to the extent that an employer gives consideration or is considering a waiver, it's important that these waivers be drafted, that are clear and concise. They should contain conspicuous terms With respect to with respect to the claims that are being waived, it's important that the specific claims be identified in the waiver. We've also been asked whether or not waivers can be used as for employees in the workplace. And I don't know. I mean, I'm sure some employers are using or are thinking about using waivers for their employees in the return to work. I think I would give extra consideration to those. In terms of employers can't waive prospective claims. There's also certain claims, employment law claims that employers that are not waivable. Gross negligence or certain claims can't be waived. So to the extent that any employers are considering waivers with respect to their employees, I would give that extra consideration. Can't waive workers' comp claims either. So there are a number of, to the extent that you would want to, are considering waiving those, creating or having a waiver, it's important that you check with, just make certain that it's compliant with your state's laws. Apart from legal obligations, I think it's important to consider the business considerations. Megan spoke about that a little bit, or some of those considerations a little bit earlier, but I think to the extent when you're talking about returning to work and safety measures, you have to consider the reputational considerations. If you as the employer choose to do nothing, obviously you're going to risk your reputation. And also you have to give consideration to the employee morale and productivity. And I think that's important. So while certain risks may outweigh others, but I do believe it's important that you consider at least the morale. And your morale might be one of the biggest factors that you consider when making safety or return to work decisions. And also you have to take into effect or into account employee refusal or resistance to coming into work. But at the end of the day, I just think you need to do a balancing act, and you as an employer have to determine what's right for your workforce. Next slide. On this slide, OSHA has put out some guidance or requires OSHA, as I said earlier, OSHA requires employers to provide a workplace free from recognized hazards that are causing or likely to cause death or serious physical harm. And as part of that, it's important for employers to determine what measures to take. And in order to determine what measures to take, the employers need to conduct a risk assessment. And OSHA has put out guidance in terms of factors or safety hazards. And those hazards range from low risk meaning jobs that do not require close contact. And those are typically your remote workers or office workers who have little or no contact with others. Then you have medium risk exposure. And those are jobs where employees have frequent close contact with others. You have high risk, and then you have very high risk. So it's important that as employers that we analyze those risks in determining what type of measures we're going to take. If we don't know what our workforce is and we don't understand the measures to be, it's kind of hard to create measures if you don't understand how your workplace is comprised or how it's comprised of. Next slide. I think you all know that the CDC issued new guidance last Thursday as it pertains to fully vaccinated people. And under that guidance, fully vaccinated people can resume activities without wearing masks or physically distancing, except where otherwise required by federal, state, local, tribunal, or territorial laws, rules, and regulations, including local business and workplace guidance. Fully vaccinated people can also refrain from being tested or quarantining following known exposure to a COVID-19 positive person and can be excluded from routine screening tests. And they can resume domestic travel without testing or quarantining periods and can travel internationally without any US-based requirements before or after the trip. I thought it was worth pointing out this guidance and specifically the language that was used. In terms of fully vaccinated means any individual who has received both doses of Pfizer or Moderna or 1 dose of the Johnson & Johnson, and at least 2 weeks have passed since administration of the final dose. I think it's also important to understand that this guidance does not apply to certain healthcare settings. It also doesn't apply to public settings such as bus transportation hubs. It doesn't apply if people travel by bus, plane, train, or other modes of transportation. It also doesn't apply jail or prison or homeless shelters. Next slide. It is important to understand that the guidance does not supersede an employer's workplace rules. And I think that's what we're all here, we want to talk about today, is how is an employer supposed to handle this new mask guidance that was issued. I think first and foremost, it's important to understand that the CDC guidance is just that, it's guidance. It doesn't trump local or state guidelines or orders that require employers to enforce the rules. There are some states that still require masks. For instance, California and New Jersey, there's one of the few states remaining that are mandating and requiring employees to wear masks in the workplace. I also think it's important to understand that OSHA is there, and that's a consideration to be considered. You have federal OSHA and then you have state OSHA. And I think it's important for employers to see what, if any, state orders there are with respect to OSHA, because some of those state orders might have stricter requirements or guidelines with respect to rules and regulations as opposed to federal. So it is important to understand if your state has a stricter OSHA regulation. With respect to OSHA, after the CDC issued its guidance, employers, even us attorneys, were wondering what would happen with the OSHA guidance that was put out in January. And at present, what we know with respect to OSHA is that it has issued a statement, and that statement simply states, the CDC has issued new guidance relating to recommended precautions for people who are fully vaccinated, which is applicable to activities outside of healthcare and a few other environments. OSHA is reviewing the recent CDC guidance and will update our materials on this website accordingly. Until those updates are complete, please refer to the CDC guidance for information on measures appropriate to protect fully vaccinated workers. And that's the only thing we've heard from OSHA since the new CDC guidance on masks has come out. So with that, OSHA has seemed to suggest, at least for the time being, that employers can follow the new CDC mask mandate. We are anticipating that OSHA will come out with new guidance by the end, or temporary standard, by the end of May. We also anticipate that emergency temporary standard is going to include items such as employers are going to be required to have hazard or risk assessments, infections, disease preparedness plans, notice of positive cases, and training. I think it's important to understand, and Megan will talk in a little bit about vaccines, but I think lots going to have to do with how employers handle vaccinations in the workplace, which is going to dictate perhaps how they handle masking in the workplace, especially if you're in a locality where there is no rule that will require masking. And again, I think it's important that an employer is going to have to weigh the risk, employee morale and comfort. Are your employees going to be comfortable being maskless in the office? I think there's going to be employees in the office who are in the workplace who perhaps can't be vaccinated and therefore are going to not be masked, and so on and so forth. Next slide, please. And so I think employers need to understand or consider how all of this, just consider. I don't know if there's any right or wrong answers in terms of how an employer is going to handle the new masking guidance. But I do know that employers need to be on the lookout for harassment or discrimination or retaliation in the workplace. Because I think, to the extent some employers have masking, have no masking requirements and are going to require fully vaccinations, there are going to always be those few employees who cannot be vaccinated or who are not vaccinated and who will not be wearing a mask, and so on and so forth. So I think it's important just to understand that, employers need to recognize that there are going to be issues with respect to masks, but specifically to the extent in terms of retaliation and employees, harassing or threatening others or not simply just not being nice. So I think employers might want to consider also, revising their policies with respect to masks. It's important. I think if you're gonna, especially this day and age, I think it's important to have a policy with respect to how employers are going to handle masking. I think with respect to the CDC's guidance and the fact that OSHA is going to be coming out with an emergency temporary standard, hopefully in the next couple of weeks, employers might want to consider, hanging back and waiting to see what happens in the next week or two before, implementing new policies and procedures and so on and so forth. The EEOC has not come out with guidance in terms of this, following this new mask mandate by the CDC. I think it's important also that with respect to this new guidance, employers should expect to see an increase in employee concerns relating to wearing masks in the workplace. So they should be prepared. I think you all need to be prepared for responses in anticipation of those questions. And I also think a good idea would be to develop a plan for messaging to employees in terms of masks. I also think it would be important also that employers develop or implement a clear reporting procedure for employee complaints. Because I do think with this new, you're going to have complaints as it relates to masks, whether someone's wearing a mask or someone's not wearing a mask and whatnot. Next slide. So with respect to the CDC's new the mask mandate, I think it's important to understand that employers still should have their safety or preparedness plans. Even assuming the workplace no longer is requiring masks, I do believe that employers should have a plan in place. Some states, and as I said earlier, some states and localities have require written COVID plans. But at the end of the day, I think it would be prudent to continue to have plans because there's going to be individuals in the workplace who are not vaccinated. So in terms of having safety measures, I think some of this is fairly, it's fairly simple, or at least you all probably know about it. But some considerations you might want to consider or continue to consider is, remote work. How are you going to handle travel? I understand workplaces are open, but how are you as the employer going to handle travel? Are you going to allow travel? Are you going to ban travel? What about meetings? Are you going to continue to have virtual meetings? Are you going to have hybrid meetings where you have some smaller meetings, larger meetings? But these are things that you as employers need to continue to consider. I said earlier with respect to the safety plans, in terms of communication. I think it's important to have a method of communication with your employees. This is, I think we all know, and you've all been if not all of you have been asked questions from your employees, and your employees want information and they want it quickly. So I do think it's important that you create an employee-wide communication method. Employee and visitor posters, education on training, policies and protocols. Next slide. Apart from just these considerations, you as employers need to consider, physical distancing. I understand the new mask guidance don't require social distancing for fully vaccinated individuals, but again, you're going to have individuals who are not vaccinated, and you as employers have an obligation to keep your employees safe. So I do think these are considerations that you need to consider to be on the forefront. Next slide. With respect to, apart from just having plans in place in terms of, in terms of guidance, in terms of, I guess for lack of word, cleaning or sanitizing the workplace. Employers still need to do this. COVID is not over. You have to consider cleaning and sanitizing, accessing, reconfiguring ventilation systems. In addition to your employees, you might have, this isn't just employee related. You might have visitors in the building, customers in the building, vendors in the building, and they may not be vaccinated. So these are all considerations that you as employers still need to consider going forward. Next slide, please. Under the ADA, an employer's ability to make disability-related inquiries and medical examination has been analyzed in three stages. It typically is analyzed in 2 or 3 stages. Pre-employment, post-employment, or post-offer, and then post-employment. And under the ADA, post-conditional job offers, that's where offers been made, but an employee is yet to start. Or post-employment is where an employee is started and then an employer wants to conduct a medical exam or medical inquiry. Under the ADA, those would be allowed. It's provided they were job related and consistent with business necessity. There are a couple exceptions there, but overall they need to be job related and consistent with business necessity. It needs to be, obviously any medical testing or medical inquiries would need to be confidential, and those inquiries or testing should be narrowly tailored. So how does that fit with COVID? When all of this first started, there was concern about the ADA and how, COVID testing or screening fit within the ADA and whether or not these would be violations of the ADA. Next slide, please. EEOC guidance states that employers can test for COVID-19 if it is job related and consistent with business necessity to determine if employees entering the workplace pose a direct threat to the health of others. So we do know that. We also know that the EEOC allows periodic testing. And the periodic testing would have to be, again, it would have to be job related and consistent with business necessity. But we also know that if you all have teleworkers or people working from home, you probably can't test those individuals because it wouldn't be job related. If they're working at home, why would you need to test them? So just another consideration, but for those employees who are coming in the workplace, it's important to determine whether or not they have COVID or any symptoms and whatnot to protect, or whether or not they would pose a direct threat to your workplace. Temperatures and screenings. The EEOC has given employers the green light to take employees' temperatures. The EEOC also allows employers to ask all employees who will be physically entering the workplace if they have COVID symptoms, or have COVID, or have been tested for COVID-19. So we know that from the EEOC. So what does that mean to us? In terms of federal guidance is that employers should consider conducting daily in-person or virtual health checks of employees before they enter the facility. You'll have to check. There are state requirements. Some states have, requirements or orders or directives concerning temperature checks and or other screenings. For instance, in Kansas doesn't have any laws requiring any temperature checks or screenings. However, in Kansas, employers are recommended to monitor employees' temperatures regularly. They're also recommended to monitor employee symptoms regularly. With respect to Minnesota, I'm not aware of any requirements for temperature checks. That's the law. But there is a law that requires employees to establish health screening process for all people entering the business entity or venue, including customers, clients, and visitors. With respect to Missouri, there's no order or requirement that temperature checks or screenings be done. However, Missouri, employers it's recommended that temperature screenings temperature screenings and perhaps other health screenings, i.e. asking questions about whether or not they have any COVID symptoms are recommended. And I think at the end of the day, temperature checks and screenings, they are not a replacement for the other safety measures. So again, lots of information, lots of unknowns, and lots of considerations. But I think as an employer, I think as employers, we just need to give good faith, in good faith consider what considerations are out there, and then once we analyze and consider the risk, I think then you can do then you put a plan in place. So with that said, I will turn this back over to Megan.
Thanks, Jill. I am going to tag on to Jill's comments about employee health screenings and talk about vaccines, which I know has been very much on employers' minds, since the FDA gave emergency use approval to the 3 vaccines we have here in the US. And your vaccine approach, is very much part of thinking through ways you can promote safety in your workplace. And I think Jill is right. You want to do a good faith kind of customized screening of what the risks are for your particular workforce. And what I've been continually telling clients is to kind of use a reasonableness standard, because if you're sued for negligence, typically your defense is that you did what a reasonable entity would have done under the circumstances. And what's reasonable for you, right, is going to depend on that customized assessment of risk in your workplace. And that's true when you think about vaccines as well. If we can go to the next slide, really we are seeing employers take one of 3 approaches around the COVID vaccines that are available. One is to educate and encourage, and this is going to be the least complicated approach legally. It comes with the least legal risks and the least legal compliance issues. You're simply educating and sharing information and voicing encouragement for employees to voluntarily choose to get a vaccine, but you're not requiring it. You're not providing extra perks. You're really leaving it to people to decide on your own. Obviously you may have a situation where if this is your approach, you don't have as many people get vaccinated as another approach. So that's what you're weighing. Another approach that we are seeing is educate and incentivize. So you're doing the same kinds of education activities, but the employer is creating some sort of perk. And I'll drill down a little bit on what we are seeing most often in terms of perks, but you're offering something extra to employees to try to motivate them to get vaccinated. And the third approach that we are seeing, some employers, but certainly not all, do, is to mandate the vaccine. We're going to do a quick poll. It's our last poll of the day. So if we can throw that poll question up again, we're just thought we would get a sampling of what approach you believe your company is taking right now on the COVID vaccine, whether you're mandating it for either all workers or some positions, depending on the position's duties, whether you're educating and encouraging, or whether you are educating and incentivizing. So I'll just pause for a minute to make sure everybody's had a chance to submit an answer. So that's interesting. So that the vast majority are taking just the educate and encourage approach. And I've certainly seen a lot of my clients doing that for a variety of reasons. And if we can go to the next slide, that this next slide lists a lot of the things that are going into the considerations, right? the next couple of slides do. It's thinking through the legal compliance issues, your employee preference issues, some of the practical issues are impacting what employers do, and that educate and encourage, with the vast majority of you picking it, that really is the least legally complicated approach. And for lots of your workplaces, probably what your employees will prefer, because they get the most freedom to pick and choose what they want to do. It looked like the second most common approach was to educate and incentivize, and mandating being the least common, at least among those of you who are with us today. I will tell you, in my own experience with my clients, most of them are either educating and encouraging or educating and incentivizing. I certainly do have some that are mandating, and we're seeing that around the country. Whether or not you mandate, I think, is going to depend on your particular risk analysis. We are seeing mandatory programs most frequently for employers that have higher risk. So we're seeing it in the areas you might expect to see it: healthcare workers, frontline first responders. A lot of my clients who work in childcare, for example, where the social distancing measures are a lot more difficult to implement, might be thinking about mandatory vaccines. It's not that it would necessarily be illegal for other employers, but again, most employers are being guided by what would be reasonable from a risk prevention standpoint, and then thinking through legal obligations and employee preferences. The most common question that comes up when we talk about mandatory vaccines is whether or not it is in fact legal to mandate. And the answer is a little bit nuanced, with the exception of a little bit of risk under the FDA emergency use authorization laws, which I'll come back to. From an employment law perspective, it will usually be legal to mandate. I'm going to give a couple caveats to that. But similar to what Jill has already touched on in terms of disability laws, normally the disability laws would place some limits on your ability to require certain types of medical exams, certain types of treatment, and to make medical inquiries. But the EEOC has come out and said that simply asking about vaccine status in and of itself is not a disability-related inquiry, as long as you are stopping at just asking about vaccine status and you are not getting into questions about additional medical conditions or diagnoses. You do have to keep that data confidential, but it is lawful to ask, and it's lawful to mandate it according to the EEOC. The caveat that I want to remind you of is that there are areas in which our discrimination laws go beyond the part of the discrimination law that says we can't do harm, we can't take adverse action based on a protected class. We also have 3 categories where employers have to go beyond do no harm to actually provide special assistance in the form of reasonable accommodations, if those accommodations are not an undue hardship, and that is in the disability, pregnancy, and religious area. And those kinds of issues certainly could come up with a mandatory vaccine program. We certainly could have people with disabilities who, because of a medical condition, cannot get the vaccine. It may not be safe for them to do that. We may have situations where pregnant employees are being recommended by their doctors not to get vaccines. And we certainly may have situations where it is contrary to somebody's religious belief to get a vaccine. And so if you were to adopt a mandatory vaccine program, you are going to have to allow for a process by which people can ask for reasonable accommodations, and you can do the reasonable accommodation undue hardship analysis that you are used to doing in other contexts. And I know Mark Matheson is going to talk a little bit more around what an accommodation process involves when he talks later in the presentation. Another risk that I do want to flag for you, and there are sort of mixed views, I think, among employment law experts around what the right answer is around this risk. But this risk has to do with the fact that the COVID vaccines that are out there right now have emergency use authorization by the FDA. So normally, as you may know, for a new drug to be approved, there's a very robust vetting and approval process that the FDA would do to authorize the use of that drug in our country. Because of the importance of developing a COVID vaccine and getting it rolled out very quickly, The FDA approved the current vaccines that are out there under a section of the law that allows for emergency use authorization. So the approval was fast-tracked. And there is a section of federal law that provides that when a medication got fast-tracked and has been approved under an emergency use authorization provision, that individuals have to be informed legally of their right to either accept or refuse to use that product. And so that means that, you know, if I go down to the vaccine clinic, I have to be told that I have the choice to refuse that vaccine. And that has raised some questions around whether then employers can in fact mandate the vaccine and whether they would somehow be running afoul of this federal law. Unfortunately, because this is a novel situation that none of us have dealt with, it's really difficult to predict in advance whether and how courts will view that issue if there are particular lawsuits around this. So some employers are just opting to say, gosh, I think I can keep my workplace reasonably safe without mandating the vaccine. I just don't want to take those risks and get into the complications. Other employees are following a school of thought among employment lawyers that the FDA issue is kind of apples and oranges to what an employer's rights would be. The FDA law around voluntary usage of the vaccine is not an employment law. It clearly was not drafted for or aimed at employers. And the argument from an employment law standpoint would be that by telling an employee that it's mandatory for them to get the vaccine as part of their employment, you are not mandating that they have to take the vaccine. What you're saying is that there's an employment consequence if they choose not to take the vaccine. But again, that's an untested area. And so a little bit of uncertainty that we will be tracking to the extent we see litigation and outcomes coming out of the courts. If we can go to the next slide, a couple of other legal considerations are whether you've got state or local laws that you need to be thinking about. Again, at the federal level, the EEOC has said a vaccine mandate is permissible. We are seeing some proposed legislation at the state and local level to prohibit forced vaccines and to prohibit vaccine passports, where employees would have to show their vaccine passport, as a condition of employment. So far, we've not seen any of those pass for private sector employers where they've gone into effect. They've largely been focused on governmental employment. But if you've got multi-state employees, it's something where you're going to want to make sure that you're aware of the lay of the land in all of the areas where you have employees located. Another consideration at the state and local level is whether there are any state lawful activity laws. And this ties a little bit back to that FDA issue that I mentioned. In a number of states, there are employment laws that prohibit adverse employment action because an employee engages in a lawful activity outside of work hours. So tying back to the FDA emergency use risk that I mentioned, if it is lawful under that FDA law to refuse the vaccine and your employee lives in a state where there's a lawful activity law that prohibits retaliation, there may be a little bit more question around a mandate of a vaccine for an employee who doesn't want it. So those are going to be some things, if you're a multi-state employer, to be thinking through. Another area of potential legal compliance in connection with the vaccine program is federal labor law. I'm not going to talk about this in great detail. Mark Matheson is our big labor law expert, but I'm just going to mention that there is a section of federal labor law, typically referred to as Section 7, that applies to all non-management employees of employers of any size, whether or not you have a union. And that section of the labor law allows non-management employees to engage in group activity. The law calls it concerted activity. It simply means group activity aimed at bettering their terms and conditions of employment. So if you have group activity by non-management employees that's in resistance to a vaccine program, that may create some anti-retaliation rights on behalf of those employees. So that's another area you'll want to be thoughtful about. One of the biggest drivers that I have seen influencing employer decisions are actually some practical considerations separate and apart from these legal issues. And that is thinking ahead to the practical question of, if you mandate a vaccine program and a large number of your employees is unhappy with that and refuses to get the vaccine, how are you going to respond to that? The normal response, right, would be some sort of discipline or firing of the employee or benching them, by putting them on some administrative leave if they won't comply with your vaccine safety program. But if you have a really large percentage of employees that responds that way, you then have a practical question around how you carry out your core operations. This is another area where Survey Monkeys, right, could be a Survey Monkey survey could be a helpful thing to be thinking about, as part of gauging employee reaction and deciding if this kind of program is really practical for you. If we can go to the next slide, I'll move into talking about, I had just a couple more points about the mandatory vaccine, and then I'll move into talking about educate and encourage. If we could go to the next slide. Two last things that I wanted to mention about mandatory vaccines. If you do decide to mandate vaccines, I did just want to remind you that non-exempt employees have to be paid for all of their work time. And if you mandate a vaccine, and that is something that employees are having to do as a condition of employment, you are then going to have to pay non-exempt employees for the time spent getting the vaccine. I've also had a couple of clients ask me about liability risks if they mandate a vaccine and somebody has a negative reaction to the vaccine. While that's a rare occurrence, we certainly have heard some stories about serious reactions to the vaccine. Most of the time, a work-related illness or injury is going to be covered by workers' comp. And so for the most part, there would be liability if in fact the cause is the vaccine and it was mandated as part of employment. But most of the time that is going to fall within your workers' comp insurance. There's a gross negligence exception, which I think is very unlikely to apply in connection with a mandatory vaccine program. So now I will move in with the next slide to talking about the educate, encourage, and the potential for an incentive program. Again, this is what a lot of employers are doing, including those of you with us today. I think it makes sense really for all employers to at least be doing some education. And education would include things like sending out, communications internally within your organization around the vaccine, around potential benefits, side effects, the way that the vaccine can make the workplace safer for your workers, and including links, on vaccine provider resources so that you're making it easier for employees who do want to get vaccinated to know where to locate the vaccine and how to go about getting that. A lot of employers are considering vaccine champions, designated employees who support the vaccine, who talk with other employees or send out messages internally. And that can be really effective, in particular, if it's leaders of the organization doing that work. The CDC website, as you may know, has a toolkit on it. It's got all sorts of helpful toolkits for employers on safety measures and guidance, but it also has some toolkits and resources around vaccine education that makes it a lot easier for employers to be doing the education campaigns. We can go to the next slide. Another thing that we are seeing employers do as part of educate and encourage is sponsoring vaccine clinics, similar to what you would do with a flu clinic. I will just raise that briefly, and I know that Julia is planning to talk a little bit more about health law compliance issues that you may or may not know can come with measures of that kind. Then I'm going to turn to talking about incentives. As I mentioned, some employers are doing more than just educating and encouraging. They are creating some perks, some extras to try to motivate employees to go get the vaccine. What we are most typically seeing in terms of the perks that are being used are additional paid time off so that people aren't having to tap into their current accruals to go get a vaccine or to take time off to sort of recover from the vaccine to the extent they have symptoms. We're also seeing things like paid transportation to get to and from the vaccine location. And I've had some employers doing gift cards or modest cash payments. So those are some examples of incentives. From a legal standpoint, there are a number of potential compliance issues around incentives, and this area of the law is a bit unsettled right now, and that may be why we saw so many of those of you who responded to the poll saying that you're stopping short of incentivizing. And the primary issue we're seeing on the employment side are questions around and some uncertainty around whether an incentive program is a wellness program. So if you think about the types of employee wellness programs that are traditionally offered in workplaces, we often will see things like weight loss programs that people might participate in over the lunch hour, or maybe there's a fitness steps challenge, right, where employees might, commit to walking 10,000 steps a day, and then there's some incentive that they receive for that. Well, because a vaccine is clearly tied to promoting employee health, there is some question around whether a vaccine incentive program is a wellness program. And wellness programs have certain requirements under the federal disability laws, the Genetic Information Non-Discrimination Act at the federal level, Title VII, to the extent that we have religious accommodation obligations under that law. And Julia will talk a little bit about HIPAA obligations. If your vaccine is a wellness program, there are a number of potential requirements that come up. And the law is a little bit unsettled around whether all of these requirements remain in play or how you would satisfy them. We used to have a set of very clear regulations that the EEOC had put out around incentives that we could look to give you all as employers clear guidance. Those regulations were invalidated by a court, and the EEOC had issued some new proposed regulations, but with the change at the White House, those regulations got put on pause. So we don't currently have regulations around wellness programs generally, or in particular vaccines. SHRM and a bunch of employers wrote to the EEOC a while back asking for some guidance, and unfortunately none has been forthcoming. I'm just going to flag for you what the potential compliance issues are, and really we're pulling this from the old regulations, and thinking that the conservative approach at a minimum is to try to comply with those prior regulations, with the view that to the extent new regulations get rolled out, they're likely to be similar in nature. So one of the requirements if you have a wellness program is that the program be voluntary, and that is because disability laws, if you are making any sort of disability inquiry, will typically require a program to be voluntary. When it comes to voluntariness, the old regulations of the EEOC said that for a program to be voluntary, any incentive, whatever that perk is that you are offering for participation, it has to be de minimis. And the idea is that if your perk is so generous that an employee just couldn't possibly resist that incentive, then the employee really is being compelled to participate and the program is not voluntary. An example might be, if you were to say, we'll cover 100% of the employee's health plan premium, right? That given what premiums cost these days, that might be something that is just too good to pass up. So voluntariness is a requirement. The proposed regulations that I mentioned were put on hold when the Biden administration took office, had provided that to be voluntary, an incentive had to be pretty modest. If you were incentivizing through some sort of subsidy towards health insurance premium, the regs had a cap in it for the amount of subsidy. And if you were doing some other incentive, the example that was given was a water bottle or something of equivalent value. And unless you're buying a really top end, water bottle, as water bottles are probably $25 or less, maybe a little bit more, depending on the brand and the size. So, as you are thinking through whether you would do an incentive, you need to think through how likely it is your wellness program. And the more modest you make the incentive, the safer it's going to be under the law. The other requirement with wellness programs is a little bit similar to what I talked about with mandatory vaccine programs, and that is that if somebody cannot participate in your wellness program due to disability, pregnancy, or religion, you have to offer a reasonable accommodation. And typically that means offering some reasonable alternatives. So if you think back to the 10,000 steps a day type program that I mentioned, if somebody couldn't participate in that kind of program due to a disability, you might be able to come up with an alternative sort of fitness or health task that they could do instead. It's a little bit more difficult, I think, in the vaccine context to think what the reasonable alternative would be to a vaccine. Maybe it's wearing face coverings now that we're seeing a loosening of face covering restrictions, or maybe it is, requiring some other extra safety measures that you're not requiring for your workforce at large. I've also had clients say, you know what, we're not going to require a reasonable alternative. We're just going to grant an exemption to the vaccine and still give the same incentive because it's hard for us to think of a reasonable alternative. The last obligation I will mention around wellness programs is that to the extent that medical data is collected, it has to be maintained confidentially. That's true even when HIPAA doesn't apply, because there's other laws that require employers to keep data confidential. There could, though, be some HIPAA obligations depending on how a plan is run. And that is something that I think Julia Weiland is going to touch on. And with that, I am going to turn it over to Julia, who is going to talk a bit. Oh, sorry about that, everyone. Let me touch on just a couple more points before I turn it over to Julia. The last couple of things on incentives that I meant to mention. If you do a cash incentive, that is W-2 income. So you want to make sure you're thinking that through in terms of your payroll obligations. I also wanted to mention that when you are thinking about incentives, if you are offering paid time off, there is a possible tax credit that's available. The Federal Families First Coronavirus Act that was in effect last year and mandated emergency paid sick leave and emergency family medical leave for certain employers. That law is technically no longer in effect. It expired in December of last year, but Congress extended the federal tax credit portion of that bill. So for employers that are still voluntarily giving FFCRA leave, even though they're not mandated to do that, if they're doing that between the period of April 1st and the end of September of this year, and if they are allowing people to take that FFCRA leave to get the vaccine, there is a federal tax credit that is available. So with those final points, I will now turn it over to Julia to talk about some health law compliance issues.
Thanks, Megan. So one question that we're getting a lot from clients is the extent to which a vaccination program implicates HIPAA. And in true legal fashion, the answer is going to be, it depends on your particular situation, but don't worry, we're going to dig into this just a little bit so that you can come away with some clear guidance on it. HIPAA, of course, governs the use and disclosure of protected health information. It applies to covered entities and their business associates. And really the application of HIPAA to a vaccine program is tied to those two defined terms, covered entities and business associates. So a covered entity includes a health plan, a healthcare clearinghouse, and a healthcare provider who transmits certain information in electronic form. A business associate is an entity or an individual that performs certain functions or activities either for or on behalf of a covered entity that involves the exchange of PHI. Now, when you're thinking about the application of HIPAA in this context, you need to think about the role and the sort of the hat that you're wearing as an employer. Vaccination cards, so we're going to talk a little bit more about this, but vaccination record cards or sort of related information, vaccine status, that can be PHI. In fact, it will be. But the nuance here is that as an employer, you're likely not going to be a covered entity or a business associate, except for a few circumstances, which I'm going to talk about. So in the context of employment, the most likely way that you're going to be a covered entity is if you hold a self-insured health plan. So if you have an actual health plan function for your employees, in that context, you may be a covered entity. When you're acting purely as an employer, that information is not going to be subject to HIPAA. Next slide. So the key here is there's really under HIPAA a distinction between employment records and health records. When you're thinking about employment records, that still can include some sort of health information that can be baked into those records. But generally speaking, employment records are not, again, subject to HIPAA. And this is because as an employer, you're not governed by HIPAA unless you're a covered entity or a business associate. So when you're thinking through the application here of your vaccine program, there's a couple questions and we're going to walk through these together. So consider first and foremost whether you are a covered entity or a business associate. Do you have a self-insured health plan? And are you offering this vaccine in connection with that program, or are you gathering information in connection with that? If the answer to that question is yes, then you're going to be governed by HIPAA and you're going to have some of those HIPAA considerations that you're going to need to work through. Now, as Megan referenced, there are some nuances when you're thinking about the context of a wellness program. Ultimately, the answer here just depends on how you're structuring that program. So if you're structuring it and you're offering or incentivizing vaccines related to a group health plan or a self-insured health plan, that could be what brings you under the definition of a covered entity here. So that could tie you into the application of HIPAA and you could have some additional considerations. On the other hand, if you're offering it really as sort of a workplace safety, sanitation, security, some of those sorts of things, that may be offering, you may be wearing your hat as an employer. So when I'm thinking about these issues and I'm working with clients on this, I really like to think about sort of the hat that you're wearing. Some employers, again, maybe having two sort of roles, one as an employer, one as a HIPAA covered entity, but you may be switching back and forth between those hats. So to consider the extent to which you're offering it and the fact that it would fall under your self-insured health plan. Now, if you're not in that bucket, if you are having this program sort of separately, or let's just say you're getting information related to vaccinations, but you're not actually administering or offering it as a program, the next thing that you really need to consider is how you're accessing that information. Under HIPAA, you can request as an employer health information. You can ask for it related to, workers' compensation and some other related claims information. You could even ask for it in the context of employment. If you do have a mandatory vaccination program, you can solicit information. Now, if you're going to get that directly from the employee, that's going to keep you outside of the application of HIPAA because employees are allowed to freely share their information and they're not governed by HIPAA as an individual. If your goal is to have a program that really requires documentation, and part of that will require you to sort of reach out to either the employee's providers or primary care clinics and solicit information. You as an employer aren't necessarily going to be governed by HIPAA, but just be aware of the fact that that primary care provider will be. So there may be circumstances in which they say, we're not allowed to share this information unless the employee has provided HIPAA authorization. There could be situations in which maybe they are allowed to share it without authorization, but this gets a little tricky under HIPAA. So again, even if it doesn't necessarily apply to you as an employer, it still may apply in the context in which you set up your program requesting and requiring certain documentation. When you have an on-site vaccination clinic, the analysis is slightly similar to this in the fact that you're going to have providers on site. Now, it may be, on your campus or on your grounds, but those providers are still going to be governed by HIPAA. So the extent to which they have information, health information, and you're hoping that they would share that with you, maybe you have a desire to have a program where you have on-site vaccines administered, and then related to that, the providers are supposed to update you on the employees that were successfully vaccinated that day. The disclosure from that provider to you as an employer is going to be subject to HIPAA. So there could be some authorization expectations and requirements related to that. Next slide. So the main takeaway is when you're thinking through how vaccination programs are going to impact you, the first question that I would ask is, are you going to fall within that definition of a covered entity or a business associate? Do you administer a self-insured health plan? Then the next question is, if you don't have that, are you using this in the context of a wellness program that could bring you within the definition of a health plan here? That will really turn on the way that your wellness program is structured. Are you offering things like reductions in premiums or cost sharings? those are really going to be health plan related benefits tied to your wellness program that are going to make this information subject to HIPAA. If you're not in that bucket, then the next consideration is thinking about how your program and how your documentation expectations, practically speaking, are going to involve and relate to providers who are subject to HIPAA. Now, as Megan mentioned, there's state law considerations as well. In the healthcare regulatory world, we have, in addition to HIPAA, generally a lot of states have health related information, privacy laws. So in Minnesota, we have the Health Records Act. We have other rules that maybe will go sort of above and beyond HIPAA. So just be aware of the fact that even if HIPAA doesn't apply, there still could be state law that restricts how you're receiving this sort of information. In the context of offering and providing an on-site vaccination clinic, it's just best practice to have as part of that your employees sign an acknowledgement and consent to vaccination, so that the provider who's on-site administering those has that written documentation up front. And then related to that would be a good time to have them also executing the HIPAA authorization form to the extent you're going to want that information as part of your employment records. Again, it doesn't necessarily have to do with you as an employer being bound by HIPAA, but it has to do with the expectations of the provider who's administering the vaccines and disclosing that sort of information. And as Megan mentioned earlier, even if you're not subject to HIPAA, that doesn't mean that you don't have separate privacy and confidentiality expectations and requirements. So regardless, you should be keeping any sort of pre-screening records in separate confidential files. If you're requesting verification of vaccination status through vaccination cards, even if those are coming from employees, they should still be kept separate and confidential, separate and apart from your HIPAA obligations. And with that, I'm going to turn it over to Mark.
Thank you, Julia. We can go to the next slide here right away. So in returning employees to work, or thinking about how this work from home era might be ending for many of you, there are a lot of reasons why employees may be reluctant or have issues with the return. And obviously some of those are the vaccine issues, of whether what the employer policy is going to be on vaccination. People may be reluctant because they've been doing well with the unemployment benefit they've been getting, the plus 300 now from the federal government, in addition to state benefits. They may be sick, they may be exposed and concerned about exposure or caring for a sick family member, and they may themselves be experiencing a physical or mental disability. So all of those things and more obviously will come into play as you are developing the work or the new return to work plan. Next slide. In thinking about these things, it's important that employers consider policies and rights and documentation issues, some of which we've already been talking about. But question one, do you have a policy that in place currently that provides employees the right to work remotely or to take leave time? Let's say, for example, you become a hybrid employer, like many of you have indicated that you intend to be, where you allow some, but not all, work to be done remotely. If you had an employee who wanted to take PTO, for example, on the days they were otherwise required to come into work, would that be acceptable under your policy? You may need to think about how that policy applies to such a situation. And if you otherwise don't have a remote work policy or a telecommuting policy in place, it might be time now to consider one. Going forward, what is the policy going to be? What is the frequency of any requirement to report in person? And are you going to make people, maintain a residence in the geographic location where your office or workplace is located? What about hardware and other system adaptations and costs involved in that? Are you going to provide people with, are you going to double your costs because now you're supporting remote and in-person work sites? And there are OSHA and work comp safety duties and liabilities to consider, even ergonomic considerations that come into place. where although you may not have an obligation to perfect the ergonomics of an employee's remote work site, there may be health insurance costs that tend to poor ergonomics in an employee's home work site. Otherwise, does the employee, aside from policies, there a legal right to some leave of absence under the FMLA or under the ADA, for example, as an accommodation? There aren't as many of those as there were during the height of the pandemic when the FICRA additional leaves were in place and required for employers to provide, but that's a consideration to consider and then to keep in mind. And then what about documentation? A lot of that's been addressed and the importance of keeping it confidential. One question that you might ask is, do we need, so let's say that for whatever reason in connection with your policies for return to work that you are requiring proof of vaccination. It may be sufficient for you to see the vaccination card or other proof of vaccination without actually retaining the card. So you could set up a spreadsheet tracker, for example, where HR or another employee was responsible for tracking whether they'd seen the proof, but you don't retain it. So now some of the documentation requirements don't come into play or become problematic for you, whether in terms of HIPAA or other privacy laws and so forth. Next slide, please. Sources of these duties and rights we've been talking about it would include individual contracts or collective bargaining agreements. I've mentioned the FMLA and possibly the ADA. Also, insurance and benefits. How does your health insurance come into play? It's not going to require a leave, but short and long-term disability benefits may be a factor in how people respond to the opportunity or the requirement to return to work. Next slide. I already really covered this about documentation. Maintaining confidentiality is important at all times. If you do keep it and retain, or if you retain the information and you have a need to share it, you should only do that on a de-identified basis. And we'll go to the next slide. Thinking about reasonable accommodation for disability, pregnancy, and religion. In the next few slides here, a lot of what applies to those three different reasons or needs for accommodation is in common, and we'll start with disability. The definition of a disability, of course, includes a substantially limiting condition that's not temporary. And so in the COVID and pandemic environment, there have been any number of attempts probably by employees to suggest that they have a disability where really they're talking about some condition that's really considered temporary and doesn't fall within the legal definition of a disability. Bear in mind that a disability may be either physical or mental, and that in any case, and this goes for all three of these reasons to accommodate, an interactive process of reasonable accommodation is expected. So you must avoid blanket policies. The analysis has to be done on an individual case-by-case basis, and you can't just apply a black and white blanket policy and say, because it may be a reasonable accommodation to deviate from your otherwise ordinary blanket policies. Also, other types of reasonable accommodation would include working from a different location, possibly remote work. Is that if let's say you adopt a mandatory vaccination policy and somebody requires an accommodation, then, well, what's the accommodation? Is it reasonable in your circumstance to allow that person to work from home, even if you're not allowing others to do so? Or is it reasonable to change a schedule or the duties of a person, or to give a leave of absence? These are all things that you would need to consider. Next slide, please. Generally, disability accommodation isn't reasonable if it creates an undue hardship on the business or presents a direct threat to the safety or health of others, as we talked about earlier. Undue hardship is a pretty stringent legal standard for a business to meet, and it would take, that analysis must take into account the size of the organization, what are the overall financial resources available to the organization, and that sort of factor in deciding this analysis. But it is the case that if something presents a direct threat and can't be eliminated as far as a threat to other workers' health and safety, then that is an undue hardship that would mean the accommodation suggested or considered isn't reasonable. In assessing the direct threat, it's also important to look at the duration of the risk, the nature and severity of the harm, the likelihood that the harm would occur, and how imminent is it. And notably, this analysis, again, it's fact specific. The same analysis that you did before, maybe a year ago, or maybe at some other time during the pandemic, might give you a different result today because of the vaccination and masking status of your workplace and the world in which we find ourselves. Next slide. Accommodation of a sincerely held religious belief is a little bit lighter burden on employers, but otherwise similar to what I've talked about for a disability. The undue hardship analysis, some examples would include if it's more than de minimis in terms of cost or compromises workplace safety and so on. But we'll go ahead to the next slide, which is concerning pregnancy accommodation. In the federal law, pregnancy is not, well, under any of the laws, pregnancy is not itself considered a disability, but it's protected against discrimination on the basis of sex, since only get pregnant. Discrimination against pregnant people is considered sex discrimination. In and of itself, that doesn't give you a due, but there is guidance, both in the federal context and in the state context, that some restrictions must be accommodated. Any kind of pregnancy restrictions or needs, such as lactation or breastfeeding needs, would need to be accommodated as under a disability analysis. And there's certain specifics that are under the Minnesota law, and these are common or similar to things that are the case under the federal law as well, where these do not constitute undue hardship. So allowing more frequent restroom breaks or food and water breaks, allowing someone to sit instead of stand at work, or limits on lifting over 20 pounds. Those are not restrictions that in accommodating them, you are experiencing undue hardship. That's by explicit definition of the statute that applies, at least in Minnesota, but it's essentially the same under the Federal Pregnancy Discrimination Act. So we'll go on. Megan talked a little bit about the National Labor Relations Act and the protection for work. In terms of concerted activity, if two or more employees are banding together to advocate for a change in your plan for return to work, or your requirement for vaccination, or any other similar thing, they are protected in engaging in that activity. You can't discriminate against them or interfere with their ability to engage you in that way and retaliate against them. They may have protected rights to even engage in a work stoppage where there are concerns about safety. And if you're a unionized workplace, you may have a duty even to bargain with the union over these issues. The next slide concerns wage and hour issues, and Megan largely covered. The next slide, please. I may have lost my connection here. Oh, there we are. The last point here is about unemployment laws, which both federal and state unemployment laws have been kind of a big deal during the pandemic. In the regular laws and then the emergency laws. There are important eligibility requirements, and those generally include that person has to be involuntarily unemployed. So just saying I don't feel safe to come to work is not necessarily something that makes someone eligible for unemployment benefits, although in certain cases it might be. And generally, somebody has to also be available for work and searching for work. But again, there are some, the emergency laws, there's some limitations on those requirements. And so if you have questions about that, you will need to look into those details a little bit further. And then, but finally, the point is also just plain reluctance, refusing to come to work, likely in most cases would result in the eligibility for unemployment benefits. And with that, I'll turn it back to Megan to just wrap things up for us. Thank you.
Great, thank you, Mark. So we are just a minute or two over. I have been monitoring the chat, as have other folks. I think we've answered most of the questions and we don't want to keep you. So we will just thank you very much for being with us today. And I wanted to let you know if there is some question that you have that you didn't get a chance to put into the chat feature, you can certainly reach out to any of us who presented and we'd be happy to answer those questions. And again, thank you so much for your time. Bye-bye.